So I warmly welcome you to today's webinar. Today we are joined by participants from different sectors. We have human rights defenders from different communities. That's from also different counties in Kenya and also beyond. We also have government representatives from National Land Commission and beyond. We also have academia and a few development partners who are joining us today in civil society organization. So welcome very much. My name is Sally Miruri and I work for Pamoja Trust. And today our webinar is hosted by a project called the Cultivating Justice Project. This is a project that is implemented by Pamoja Trust, an organization called SEPCJ. SEPCJ in full is Center for Education Policy and Climate Justice, and also done Church Aid as our lead implementing partner with funding from the European Union and also from Danida. So for this project, our major objective is to promote responsible business conduct and also to strengthen human rights in agribusiness, but also ultimately to look at how we can ensure sustainable economic development that also contributes to sustainable livelihoods. So welcome to today's webinar once again. So as I've mentioned, this webinar is our second series of webinars that we seek to hold from now up to the end of the year, that is December. And the reason why we are having these webinars is that we're trying to create a platform for discussions on business and human rights and how we can ensure that businesses continuously undertake their businesses in a sustainable manner, while communities also continuously benefit from these businesses. So during our first webinar, for those who were part of the first webinar, you remember we explored multiple doors to justice on how we can strengthen access to remedy, especially for communities that are affected by business activities. And from that webinar, there were very rich insights. And if you listened keenly, there was one issue that continuously arose, which is land, how we can deal with land. So when we are talking about business and human rights, whether we are talking about businesses in the sector of agribusiness, whether we're talking about infrastructure, whether we're talking about renewable energy, urban development, land seems to be at the center of it all. And that's why we are having today's webinar. We want to use this opportunity to unpack the issue of land and get into the depths of it. Why do we find land a big challenge when it comes to discussions around business and human rights? So to set the context for today's discussion, is just to mention that land is much more than a productive resource. For many communities, and also for the participants that you're here, you'll agree with me that land is a source of identity. We usually ask ourselves, where do you reign from? Where do you come from? So, and of course, it's connected to land. It gives us an identity in terms of culture. That's where we get our livelihood from. That's where we get food security from. So land is a very important topic. At the same time, when we talk about businesses, it's also at the center of investment for any project to begin. So it's the first question anyone asks, where will we do the business? So that's also make land something that is a topic or a discussion that is very important. So when we talk about challenges, when we talk about weak land land governance is weak and communities experience social impact, we ask ourselves, what challenges are communities really facing when it comes to land issues? And as people in the land sector or even communities who respond to issues land, what do we need to do to make sure that the challenges that arise from land issues are then dealt with? And that's why today we have an expert that deals with land issues and also someone from the commission that has a mandate when we're talking about issues to do with land. So before we begin, I'm not so sure if our partners have already joined, but I would like to acknowledge them. Today's webinar, of course, has been made possible. I mentioned it's under the Cultivating Justice Project, but it has also been made possible, of course, by Pamoja Trust, who's hosting this webinar today. We have SEPCJ. I mentioned SEPCJ is Center for Education, Policy and Climate Justice, and also done Church Aid. I think when time comes, I'll allow them to also contribute to the discussion as we continue. To the interesting part now. Allow me to introduce our speakers today. We have two speakers, a representative from the National Land Commission and also a human rights defender who is critical because they are the first responders when it comes to challenges of land. So, ladies and gentlemen, today we are privileged to have two speakers. Our first speaker is from the National Land Commission, as I've mentioned. The National Land Commission, as per our Constitution of Kenya 2010, is the body that is mandated to manage public land on behalf of national and county governments. They also advise on land policy. They're very key when it comes to addressing issues of historical land injustices, which I think we'll discuss and unpack more during this conversation. So it's my pleasure to introduce to you Mr. Opaa. Mr. Opaa is a distinguished transdisciplinary scholar. He's also a social ecologist and a land governance expert, and is currently serving at the NLC. He also brings a wealth of experience to this discussion today because he has experience on land governance and natural resource management issues, climate resilience, human rights, and also gender equality. So throughout his career, he's worked on issues to do with research and also policies, and you can see that through his contribution to various policies. He's played a leading role, especially in development of several landmark policies. That's the Kenya County Natural Resources Atlas. That's a very rich resource when it comes to reference materials. He also has participated in the development of wetlands conservation and management policy, and has significantly contributed to advancing policy discussions around agroecology, food systems, land governance, and also natural resource management. So beyond his work at National Land Commission, he also serves at the national and regional advisory platforms, including the National Land Policy, Mining Governance, and Aquatic Research. He's also published a lot of journals, international journals, something that maybe he can also share with us the links today during our discussion so that we can always refer to them even after this webinar. So Mr. Opaa says that his commitment, he has a deep commitment to people-centered land governance, and that's why he's best fitted for this webinar today. So I'll just introduce the second speaker so that we just get into the discussion immediately. So that's Senior Opaa. That's how I'll be referring to him in this webinar in the National Land Commission. To our second speaker. Our second speaker is a human and environmental defender. Most times we call the HRD's activist. He brings invaluable first-hand experience from working with communities affected with land-related issues. And through this perspective, we hope to better understand also the reality of communities, the realities that the community face, and identify practical pathways towards justice and accountability, of course, through his experience. So I introduce to you Mr. John Muchori, a governance and public policy practitioner, and also he's a programs coordinator at Bunge Mashinani Initiative. He has extensive experience in democratic governance, land governance, civic engagement, and also social accountability and constitutionalism issues. He's widely recognized for leading community-driven campaigns that successfully, for example, the one that successfully influenced the Kiambu County Valuation and Rating Act, that is the Act of 2016. So he's very critical in leading campaigns and also engaging communities. So through his career, John has championed meaningful citizen participation and community-led advocacy. And today he will share practical insights drawn from his work and also working closely with communities, and also being someone who lives around some of the big business investments in the country. I think he'll also share some of the experiences and the observations that he has observed as he executes his work. So join me as we welcome today Ben Opaa and John Muchori. So without further ado, I want to transit back to Senior Opaa from the National Land Commission. He'll be talking to us today around the role of the National Land Commission in protecting community rights and access to remedy. And I welcome you participants as we have this discussion that we can explore the tools that we have in the webinar. That's the chat. I know we have not given you rights to use the mic now, but we'll be able to enable those rights. So introduce yourself in the chat, tell us who you are, where you're joining us from, also how you're feeling. I think that's a practice that we are adopting. We always tell each other how we are feeling. For me, I'm feeling hopeful that we're going to have a good discussion today, rich discussions today that will ultimately help us resolve some of the challenges that we have at community level, especially at the grassroots level. So welcome, guys, and I encourage you to use those tools. So Senior Opaa will be talking to us about the role of the National Land Commission in protecting community rights and access to remedy, as I mentioned. And we also encourage that we can ask questions as we even listen keenly to him. So I want to welcome you, Senior Opaa. The floor is yours. Senior Opaa, if you can hear me.
Yeah. Thank you very much, Sally. Can you hear me?
We can hear you clearly. Karibu.
Are you able to hear me, Sally?
We can hear you clearly, Senior.
Hello?
We can hear you.
You can hear me?
Yes.
Okay, thank you. Yeah, of course, you have given a very detailed background about myself. And I want to confirm, yes, it's true. I work for the National Land Commission. And I normally say, yes, I work for the Land Commission. But before that, I work for the people of Kenya. The people of Kenya currently stands at around 56 million, almost. So those are my employers. We call it We the People under Article 1 of the Constitution. I'm just stationed at the Commission as a public servant. So my employers are basically you, the Wanjikos, the Sabinas, and all that. So as a Constitutional Commission, of course, you are aware that we are the brain trust when it comes to matters land, and of course, streamlining land reforms in the entire Republic of Kenya. And that has become apparent in view of the many challenges around land, which some of them are actually historical, particularly in regards to public land allocations that were illegally or irregularly allocated according to the Ndungu report, but of course which has actually bothered Kenyans, and therefore upon that they decided to establish an independent constitutional commission within the Constitution of Kenya 2010. Basically their interest in regards to a vital asset called public land. But the commission does not just have the public land management portfolio, it is called National Land Commission, not National Public Land Commission. So we also have jurisdiction over private and even community land as a safeguard institution, and of course having an oversight responsibility on land generally. So when you look at, for example, Article 66 of the Constitution, which empowers the state with the powers to regulate use of any land, then that, you see, is the police power of the state. And that part of that is basically brought down to the commission and operationalized under Section 8 of the Land Act, of course, providing the commission with those powers to, kind of encumber or caveat or guide specific decisions around land use in private, community, and even public. That is very, very important in regards to the discussion that we want to have. But again, also I want to emphasize that the Commission has quite a number of portfolio, or in terms of mandate, established very well in Article 67, sub-Article 2, and you have said them very well. One of it is the administration and management of public land, and of course public land is clearly defined under Article 62 to mean so many things, including forests, minerals, water catchment areas, all our water bodies, all our rivers, all our roads, public roads, and thoroughfares. They are all described as public land in the context of land governance. One of the things that you may want to follow through now is the aspect of business-related concerns and violations in the context of land. And of course, I will also be coming through in regards to land as a physical commodity, but also land as a natural resource. And that natural resources are also defined as land. My reading of Article 260 of the Constitution actually clearly defines land to mean a plethora of things, but they are basically classified as 5 things or 5 elements. One is that land in Kenya, to Kenyans, land means what we normally know, the traditional physical surface of the earth and even the subsurface rock. But land also means in Kenya any water body. So any water body in Kenya, rivers, lakes, all those swamps, springs, all those are actually land. Land also means the marine waters and the exclusive economic zone under Article 260. And so even those that are living around marine waters, like the coastal communities in Kwale, Kilifi, Lamu, Tana River, Mombasa, that marine water is land, and it is public land in that context. Again, also land means natural resources. I'm not sure why the drafters of the Constitution decided to separate water, marine waters, rocks from natural resources. But they went ahead and said land also means natural resources. And they defined natural resources within that same article, Article 260. And of course, finally, land means the airspace. So with that definition, now you can understand why the Commission has a very central role when we want to talk about business-related concerns and violations, especially in regards to land. One of the things that we see, Sally, very, very quickly, I know you will be coming back to me, is we see imminent evictions. Some of them are not properly legally grounded or informed. We see displacement of local communities who are voiceless, whose voices are completely suppressed, especially by the state and the corporate bodies. We also see aspects of unfair compensation. You know, your land is taken, but then the compensation does not necessarily justify what probably you're expecting. Of course, the valuers who value land are also guided by their own ethics and standards. But one of the things that we see, which is a concern, is the whole issue around compensation, and just compensation, but also untimely compensation. Our Constitution is very clear under Article 40 that we need to have the compensation must be just and prompt. So in that regard, the promptness or the timeliness of the compensation is a major issue or a human rights issue, because sometimes your land is acquired and the commission or the parties that are supposed to compensate you will take maybe 10 years. We have seen some members of the community coming to the commission and they are really in dire need of their money. The land has already been compulsorily acquired in line with the Constitution under Article 40 alongside Section 133 or Section 107 all the way to 133 of the Land Act that provides a comprehensive procedure on public land acquisition process and what needs to be done. But then they come to the commission really complaining because of those delays, which is a major issue and a human rights violation, because there's what we call the value for money, and the value for money has a time limit. What I was paid, if I was paid 200,000 today, and then you pay me the same 200,000 in 5 or 10 years, they're not the same. So we see that also coming out very clearly as a major aspect or element of human rights violation within land and even a corporate-led business developments on land. We also see specific human rights violations when we talk about I've talked about compensation, human rights violations, procedural issues around participation or meaningful participation of local communities and the Kenyans, because again, Article 10 of our Constitution requires that people must be properly informed so that they can meaningfully participate in a democratic process. For example, if it is mining, if it is the establishment of conservancies, if it is the establishment of these climate change projects or climate finance projects, if it is the establishment of large-scale agricultural interventions like the Galana Kulalu, so that people can participate and provide their views. Of course, you are aware, Sally, that the Supreme Court had already provided a very robust standard for public participation. And one of the things that is coming out from that particular judgment is the aspect of public participation should not be carried out as a mere ticker box, as an illusory process, but it should be meaningful and should mean well. The officer carrying out the public participation must mean well to the general public. But we see a deviation that public participation currently is carried out more as a ticker box. We want just to fulfill a legal obligation. For example, when you look at the environment and social impact processes, alongside other processes of governance on land and natural resources. So there are a myriad of issues, Sally, that but allow me to pause there as I wait for more time later, maybe to inject in. Thank you. Back to you.
Thank you, Senior. Thank you for those reflections and for reminding us what land is. that is not just the surface of the earth, but it goes beyond the water and the definitions that you've given us, but also for highlighting the challenges that you've been able to observe even from the side of the National Land Commission. I think we have continuously raised some of the challenges that you've talked about, like the evictions, displacements, and we have oftentimes termed them as the social impacts that communities continuously face when it comes to land issues. John, I know you're here and you also work closely with community members and grassroots organizations, but we also work alongside some of the big businesses and investments that have acquired huge tracts of land, some which come with a lot of historical land injustice issues. So just to add to the discussion and on what Opaa has already said on the challenges, what are some of the observations that you've made when you're working with communities in terms of their land issues? Karibu, John.
Thank you very much, Sally, and good afternoon, everyone who are listening in. Allow me to thank Pamoja Trust for inviting our organization, Bunge Mashinani Initiative, to be part of this important conversation, which is very crucial also to the work that we do at the community level. It is my privilege to be in this platform with colleagues from government institutions, civil society, HRDs, development partners, academia, and also the citizens. I remember when I received this concept from you regarding today's discussion, Land First, addressing the root cause of business and human rights violation, and also preventing conflict and strengthening access to remedy. For a moment, I paused and felt that it has really captured something communities have been telling us for years. Often not, we have been discussing business and human rights. We focus on what happens at the project that has already begun. We talk about pollution after a factory has been built, unsafe working condition after employees have been hired, and also disputes after communities have already gone to courts. Those conversations are very important, but today allow me to invest my time to ask some different questions and difficult questions. What if we started much earlier to have conversation in these issues of BHR? What if we looked at the root cause instead of only responding to the consequences? But from my experience working with communities across different contexts, I have learned that many of those problems do not begin in the workplace or at the project site. They begin much earlier, and they begin with land. They begin where land is involved. Look at a point where a road has to be constructed. Land has to be identified. Look before a factory is built. Someone has to identify or decide where it will sit. Before mining licenses is issued, there is a land involved. Before a renewable energy project takes off, then there is a factor of land. And because land comes first, it is always where many of the relationships between communities, government, and investors are either strengthened or broken. That is why I believe as a HRD that if we truly want to reduce business-related human rights violation, it is important for us, or rather, we cannot wait until construction begins or until communities file case in courts. We have to start much earlier. We have to start where the conversation begins, and we have to involve HRDs, and that conversation begins with land. Speaking from experience, and today I won't speak as a lawyer, neither as a government official or an investor. I'll speak as someone who, I've walked this journey with communities. where over the years we have facilitated civic education forums, supported public participation processes, held communities understand their constitutional rights, and worked with citizens as they sought accountability through peaceful and lawful means. Those experiences have really shaped how we understand development, and one lesson that has always remained constant is that communities rarely are against development itself. In fact, if you sit down with and have a real conversation, a honest conversation with communities, you will quickly realize that they want the same things that we all want. In these case, communities want better roads, they want reliable healthcare, they want schools for their children, they want investments that create jobs, they want clean water, they want economic opportunities for their young people. So that question has never really been whether communities support development. The real question is how that development happens, and that is my experience and where the problem begins. It is true that communities face quite a number of challenges, and as my colleague Ben has stated, around poor access to information, lack of meaningful public participation, insecure land tenures, fear of displacement, loss of livelihood. These are the challenges that communities do face. Whether we are speaking to communities affected by infrastructure project or urban development, communities impacted by agriculture or conservation initiatives or industrial investment, the concerns are always and often very similar. So the first challenge is usually information. And many communities hear about a project after important decisions have been made. Sometimes they hear rumors before they receive that official communication from respective government institution or investors. Other times they see surveyors arrive in the area before anyone can explain to them what is happening. That uncertainty creates anxiety, and people begin asking questions such as, why are people measuring our lands? Who approved this project? Will we lose our homes? Will we be compensated? Where can we, get accurate information? These questions truly are perfect, legitimate questions, but unfortunately, when answers are not provided early enough, rumors begin to fill the information gap, and once rumors take over, trust within these institutions or corporates start to disappear. That is why we often say that access to information is not simply a legal obligation. It is one of the most effective conflict prevention tools that we can ever have in dealing with business human rights violations. Again, communities understand what is happening. On the other hand, another issue quickly emerges, and that is the issue of participation. Many people speak up that yes, we attended a public participation, but the question is, did our concerns, be taken into consideration? But we tend to ask and do follow-ups to this question, and different pictures begin to emerge. One discovers that the meeting, yes, took place after major decisions had been made, and you learn that technical reports were presented in a language that many people at the community, at the grassroots, could not understand. Sometimes women and young people, person with a disability, or minority groups were not adequately represented. So while participation may have taken place, many communities do not feel they were genuinely involved in shaping the decision that affected them directly. That distinction is extremely important. There is a difference between being invited to a meeting and being meaningfully involved in decision making. Within our organization, meaningful participation gives people an opportunity to influence outcomes. Procedural participation simply records attendance, and we need to actualize and be cognizant that communities know these differences. The third issue that we frequently hear is about compensation, and my colleague Ben has really brought it out very clearly, that whenever compensation is discussed, people naturally think it's about money. But in communities, they rarely speak only about money. They speak about livelihoods. They speak about dignity. They speak about their identity. They speak about farmers who have spent 30 years cultivating the same land. Compensation cannot simply be calculated by measuring acreage. The land represents years of hard work, food security. It represents the family history. It represents the future income. The same applies to pastoralist communities whose livelihoods depend on grazing land, and indigenous communities whose connection to that land is deeply cultural and spiritual. So this is why compensation must always be understood in its broader human context. It is not only about replacing land, it is about restoring livelihoods. I think I'll leave at that as we get into it, as I'll be discussing on the experience that we have had in Kiambu County under the Kiambu County Valuation and Rating.
Thank you, John. I don't know if it's just me or we've lost you, but I think you're also finalizing. So thank you so much for those thoughts. I think what's being heavily about public participation, access to information, and I think Opaa also had talked about issues of challenge of adequate information when it comes to land issues, especially during acquisition processes and at the onset of projects being a real issue. Ben Opaa, as you come back, I know the National Land Commission was back to deal with some of the challenges that we're talking about, land challenges, including the historical land injustices. So just some insight on how has the Commission tried to handle some of the land injustices? Because as we talk about business investments, needing land as the very first material or tool to be able to execute their businesses, we also acknowledge that as a country, we are coming from a history where we have continuously experienced issues to do with historical land injustices. So before we even go to the issues of compulsory acquisition, how has the Commission tried to handle some of the historical land injustices and where are we at? And as you give us a bit of insights, touch a little bit on when you talk about adequate participation. I know courts have continuously pronounced themselves on what adequate participation and even access to information could entail. How do you, as a commission, look at adequate participation in terms of like the procedure when a business wants to acquire land? That this can be a private business or even government-based business. What is the process to make sure that communities are engaged and they have the information to really understand what is happening and how their land is going to be dealt with? Karibu Senior.
Yeah, thank you very much, Sally. Yeah, those are two broad related issues. Allow me to start with the historical land injustice claims. Of course, I mentioned earlier that the birth of the National Land Commission was not a nice one. The commission was birthed out of a lot of emotions, trauma, and stress. And so Kenyans decided, how do we deal with our emotional related stress and depression around land governance? And so they gave themselves a commission. But of course, one of the stress sources or causes of stress and depression that resulted into the establishment of the commission was, imminent historical land injustices, where the state, arbitrarily acquire rights of individuals or even communities. And of course, policy-related issues or interventions that also occasion some dispossession and displacement, so to speak. So we have a history, and that's why we call it, you call it historical. Constitutionally, when you look at the framing of Article 67, where part of the functions of the commission is to investigate current or present and historical injustices. The constitution or the constitutional framing gives it a slightly wide berth than what Kenyans kind of perceive. They would want to call it historical only, which of course is a sub-component, but the Constitution has also provided the Commission with a leeway to deal also with present injustices, noting that even as we engage in this particular webinar, somebody somewhere is perpetuating and exacerbating some injustices somewhere on land. So the Commission is expected to deal with that. And of course, that forms a fundamental function in the broader functions of the commission, which we kind of situate as a quasi-judicial function of the commission when we look at the investigative powers of the National Land Commission, the commission having powers to investigate present and historical injustices, but also importantly to review grants that were illegally or irregularly granted, especially in terms of public land. So when you look at that, then you come in to realize that the recognition of historical land injustices is not rhetoric. It's not a mere, pen to paper, but it is a deep issue that the commission is critically looking at. And of course, our previous commissioners have dealt with a bit of that in terms of where the law was. The law had already provided for the commission under the Land Act, formerly it was Section 38 or thereabout, that had already granted the commission the powers to actually investigate historical land injustice. But then you also realize that that process was timed, Sally. It was 5 years. And so the commissioners, the previous commissioners, were able to do whatever they were able to do in terms of admitting claims and of course, subjecting those claims to a specific admissibility criteria, which is also provided for in law. And so after that, we were able to process and make recommendations. Remember, the Constitution has also instructed us to make recommendations to appropriate agencies or government authorities in order for them to implement those recommendations. Of course, the challenges around historical land injustice are still staring at us in terms of, one, do local communities really understand the meaning of a historical land injustice in as much as it is in their mind? And what I'm looking at here is that the local community's capacity to decipher what really constitutes a historical land injustice based on the law is not what they perceive to be the meaning of a historical land injustice. And so you'll find that when they're framing their issues and when they land at the National Land Commission, then the commission, when we sit down to review them, or even just the first stage of just filtering that or subjecting it to the requisite admissibility criteria as provided for in the Land Act, then you find that they fail. They fail the test of admissibility because of the framing. So it is about capacity, again, that is related to the framing. And of course, our communities still do not have the capacity to really frame and adjust their mindsets, including their claims, to fit into the required admissibility criteria for a historical land injustice as defined under the law. So that is one of the challenges that we are facing. So we could have, like the last regime, we had over thousands of claims, but we were only able to admit less than 1,000 or so. Yeah, and it's because of that capacity issue. Of course, Kenyans also think that when they have a problem with their neighbors, and maybe their neighbor kind of overstepped the boundary, then that they would constitute, or they would regard that as a historical land injustice. So we have what is provided for in law vis-a-vis what people think should be a historical injustice. There's that particular gap or lacuna. The other challenge that we also find with the historical land injustice, of course, I've talked about the legal provision. The legal provision initially had already timed the process, and so a lot of communities were time barred. But I think there was a petition, not I think, but I know there was a petition that was before court, and the judgment was delivered and struck out that repugnant section of the law that was kind of timing or providing a timeline for the commission to review or investigate and review historical land injustice and make appropriate redress. And of course, now we are now enjoying the latitude of a new legal regime that has now given us a lot of hope and prospects in relation to permitting Kenyans to submit their claims. At the moment, the Commission is organizing its governance. We have a proper governance in terms of committee structures at the Commission, the Legal and Regulatory Committee, where historical land injustices are being reviewed or will be reviewed under the current tenure of new commissioners in the next few months. I don't think around September, we'll be going out to invite those particular claims for communities and the public to start submitting their claims for historical land injustices review. So that is the status. When you talk about information, tying that to information, of course, one of the major issues we are seeing or we are witnessing as a commission is what I call information asymmetry. Information asymmetry in land governance is a major issue because whoever has information has a lot and stands a better chance to negotiate and even to get it all. Information asymmetry, for example, I want to lay it bare for you, Sally, together with the participants, that in the mining sector, for example, when you look at the transactions or the dealings or the negotiations, you'll find the investor having more information. He even knows, or she even knows, where exactly are the minerals. And sometimes the minerals are actually next to your land or next to your particular homestead, or they're within your land. But you as the landowner or that particular local community, you are not even aware. But the investor, in this case, the mining company, is already aware, having too much information, and probably is working in cohort with the respective government agencies to kind of hoodwink the community member, or even subvert the law to dispossess this particular community member so that mining can be effectuated in his or her private land. So information asymmetry is a major issue of governance. When you talk about business and human rights on land and natural resources, a major issue. And we are saying that we must cure that challenge, that there's this segment of the society that has too much information, and there's this segment of the society that has too little information, because that actually also informs your participation and involvement, including your input to a particular governance process in relation to both land and natural resources. So information, access to information, of course, is provided for under Article 35 of the Constitution, but effectuating that article has become a major challenge. Coming down to the final part of it that was of concern to you, how the Commission is basically bringing out the issue or dealing out with the issue of public participation. Yes, as a Constitutional Commission, Sally, I would tell you without fear or doubt in my mind that we are a Constitutional Commission, and one of the things that we do without looking the other side is to ensure that our land-related processes or land governance processes really are constitutionally grounded and legally sound. We're just from a meeting or a launch of a particular public document where we undertook very, very robust and rigorous public participation. And I want to just give you a skeleton or a sneak preview of what we think and we view should be a meaningful public participation, which resonates very well with the various pronouncements from the courts, especially the Supreme Court judgment on the standards for meaningful public participation. One of the things that we look at or we consider is the venue. Is the venue for the public participation really, really accessible? Will local communities or the targeted audience that are expected to participate in this particular important governance process or meeting, will they be able to participate? How do we support or facilitate them to participate? Remember, you do not want to also kind of tokenize public participation. That people come to public participation because you have given them 1,000. But you want their contribution, appreciating that they have in-depth knowledge and experiences, as well as unique perspectives around that particular governance process. And so you are soliciting for their inputs into that vital process. So you're not going to do a ticker box. The venue becomes very important. 2, the timing. What time is your meeting? What time do you want to engage them? Is it the time when women are out gathering fuel, or they have gone to look for food for their children who are coming back at lunchtime? When you look at the dry land landscapes of the Republic of Kenya, where we are having community land registration, timing becomes important because of the weather, the heat. People wouldn't wish to participate in a meeting that would go past 1 o'clock, for example. So timing becomes another criteria. But importantly, how do you gender or engender the public participation process so that women, people with disability, our youths, and even the Gen Zs, whom we are currently seeing to be being relegated at the periphery, should meaningfully participate and be involved in the governance of land. The law has already provided for, in the case of Article 10 on public participation, which has also breathed life to the Community Land Act for the Community Land Management Committees in terms of the obedience or adherence to the third gender rule. So there are a number of things that we look at: the gender aspect, the gender parity issue, the timing, the access to the venue, the aspect of what the trade-offs. You have to look at the trade-offs. If somebody is to walk 10 kilometers, a Maasai person has to look at, 10 or walk 10 kilometers to come and participate. What are the trade-offs? Do you think this person would actually come for your meeting, or they will be busy going to herd their livestock? So you have to consider all those dynamics. But ideally, at the bottom of this is what we call the doctrine of public trust. do you mean well? Do you want to carry these people along, and you mean well in terms of this genuine public participation, and that you want to get the best out of the people? So some of those characterization or criteria become very important when you want to establish effective public participation. Of course, critically, apart from the timing, you look at aspects of trade-off. When these people have to lose their time or come for your meeting, what do they stand to gain? And again, also the language. What is the language? If you're going to use a legal notice, traditionally we communicate, especially in government, through the gazette notices. How many Kenyans read those gazette notices or newspapers for land acquisition, for example? The law requires that, but you have to go beyond what the law requires. As a public officer or as National Land Commission, we do that because we are expected to make sure that information availability is provided, that there's a lot of information at the chief's camp, at the churches, at the schools, anywhere that the local communities are supposed to engage. And of course, even local radio stations, we expected to do that, and we do that occasionally when resources become available. And of course, resource constraints is a major issue that actually impedes a meaningful people's participation alongside other structural deficiencies. Back to you, Sally. Sally, you are not mute. You are mute, yeah.
Apologies for that. I was just saying thank you so much, Senior, for those very triggering insights. I must say, there's something you say that is very spot on. That all these issues has to also come with doctrine of public trust. I mean, if you have the goodwill, when you talk about procedure, then you'll be able to achieve what we've continuously called adequate participation. Thank you so much. Even as you mentioned, issues of historical land justice. Sorry, John, you can just mute for a minute before I give you the mic. I think you've also talked about issues of historical land injustices. I think for this platform and also for our participants, I think that's very rich information. Even because we get into the second session of second review process of the HLIA cases. I think some of the participants can also take that opportunity to deal with some of the challenges that they continuously say that are still facing. I know you have heard of the National Action Plan on Business and Human Rights. That's a policy that is trying to guide us on how to kind of work collaboratively with businesses, especially in the country, to make sure that during their works or their operation, they do not infringe on human rights, and especially when you're talking about land issues. And looking at that policy that right now I think is due for review, there are certain policy actions, of course, that were also directed to the Commission. For example, of course, you've mentioned issues of education, issues of Community Land Act, but also issues to do with how to handle fair compensation. And you remember John had mentioned that sometimes communities do not only just want compensation. When you talk about land and we talk about like human rights issues and access and use, adequate use of land, we're also looking at how this land translates into better livelihoods. So when you talk about issues of benefit sharing, for example, for communities in SL areas like Turkana, who of course will give their lands, but they'll also maybe want other issues that may contribute to better livelihoods. How has the Commission maybe tried to address the issues that were in the National Action Plan on Business and Human Rights, especially in regards to bettering livelihoods, on how to deal with issues of benefit sharing and also other activities? I know businesses sometimes look at them as CSR, but beyond CSR, how has the Commission ensured that they monitor how businesses execute their works in regards to bettering livelihoods? Karibu, Opaa, I give you the mic again before we go to John.
Yeah, thank you so much, Sally. The National Action Plan, the current one, did not take care of land and natural resource related issues or matters. and even business and human rights in relation to land and natural resource. I'm aware because I'm at the center of the current review of the current National Action Plan for Business and Human Rights for Kenya, and we are now onboarding strategically land and natural resource as a pillar or as a theme or a thematic area to be embedded in the subsequent National Action Plan for Business and Human Rights for Kenya. And so in that regard, allow me then to state that we are being strategic at the moment as a National Land Commission. We are actively participating in the review to embed properly business and human rights issues, violations and concerns alongside the risks in land or on land, as well as natural resources. And we are now proposing robust safeguards to mitigate against potential human rights-based violations and concerns on land and natural resources in regards to businesses or investments. We are also strengthening appropriate remedies or institutional architecture that would provide remedies, not just the formal, but also informal institutions in that regard. And we have very, very functional informal institutions when you talk about remedies. For example, our traditional governance systems on land. I would give you a practical example. In Isiolo, the Borana community have this nether system of land governance, which of course has been working for them. And how do we strengthen that? And of course, infuse that or integrate that in our ongoing discourse around review of our current National Action Plan on Business and Human Rights. I would also want to tell you that the issues of compensation are coming very well, and a lot of stakeholders are actually bringing that as a major issue of concern. They do not feel that the National Land Commission is really compensating them well. But allow me to clarify two things in regards to compensation, Sally. That one, compensation is governed by a very robust framework or law alongside international standards. So the valuers are guided by even international valuation standards. For example, in Kenya, when we value your property, there are three components regarding that particular property that will be valued or will provide certain value. One is the land itself. How much is the land? And of course, in this case, we look at the market value. And we are able to assess this based on records within the registries, because people do transactions on land. So how much are these particular communities transacting for a particular community, for a particular property in this particular zone? And of course, we're also guided by the valuation rules across the entire country. And we know this zone, these are the kind of values that we are supposed to attach. So we start by valuing your land. The substratum of the property rights here would be land. And so we value land based on the market values, based on comparative analysis or comparative, what we call comparables in valuation, and we're able to get the actual value of your land, whether it is in Isiolo, whether it is in Turkana. We are not faking it. We are using standard methodologies based on the law and of course professional standards as provided for in the professional code of ethics. Then the second category that we value, Sally, for the sake of information, is what we call developments on your land. If you have improved your land by building or establishing structures, a house, for example, we value that. And we value whether even the tiles, we look at the quality of the tiles. If it is a mabati structure, we look at the quality of the mabati, including the finishing that is inside that particular property. That is valued. And so you'll find that people who have actually improved their lands would get more value than even the land itself. You can even find that the land itself is 200,000 shillings, but the property on the land would go to even 40 million. So depending on how you have improved your land, that is what will make you get more or less. But you are in the same vicinity with your neighbor who could be having just, a simple structure, and therefore that comes in. Of course, I have problems with that as a natural resource expert. The third area that we also look at, apart from the two, the property, the improvements, and even the land itself, is what we call the disturbance allowance. So the National Land Commission provides you with additional 15% as a disturbance allowance. And that is now computed, and that is able to give you the actual value of your property for compensation. And then you are given an opportunity to sign an award if you agree with that particular value that the commission has proposed, you sign. If you don't, you can proceed and lay that particular claim in a particular remedy. We call it the Land Acquisition Tribunal, for example, who will listen to that your case and will be able to direct the commission on what to do or sustain the value provided by the commission. So that is how we do our valuation. The beef that I have with that, of course, is the whole concept about valuing our resources and the livelihoods in this case. If, for example, I am a pastoralist and I've been using a particular place to graze my livestock, how much is the grass that I've been using or utilizing to graze my livestock in that particular area? How do you compensate for that? And suppose I've been using this for 40, 70 years since a child. How much am I going to lose? So valuing our natural resources within the broader land valuation is a major issue of concern, which we are trying to address as a commission. Of course, when you look at even values or valuation, if a place is regarded as a swamp or a wetland, then you'll find that attracting lower value, while in the ideal, that should even be having slightly, higher value than even the traditional dry landscape. So there are those disconnections or challenges around valuation that we are also addressing, so that our valuers become aware and become, appreciate the dynamics within a landscape, especially in regards to access and benefits from natural resources that they often undervalue or completely neglect in the valuation process. So I would allow me to stop there for now. Sally, back to you.
Thank you so much, Senior, for that informative information. I think we're taking notes, and I can see that a lot of questions are coming up. I know I want to get back to you, John, but just to bring on board also the participants so that we also allow or give time to also address some of the questions that are coming up. I think as Senior Opaa was concluding, he's talked about issues of also remedy, even as he has given us the process of how they do valuation, and if there are any issues, what should be done. I think remedy is also something that we're very keen on in this project, that we do not only put structures to deal with procedures, to deal with land challenges, but we also make sure that ultimately the communities are able to effectively resolve some of the issues that they have, especially on land issues, or even, let me call them violations or disputes. So I don't know if Isaac Wanene is here with us, but he had submitted a question which I wanted to talk to before I go to the next of the questions that are coming up. That's John. He had asked that if you look at our Kenya current legal and regulatory framework, some of which Senior has talked about, do you think they're effective in holding our businesses, especially the big business investments, accountable on land issues? That was his first question. The second question, he had asked that what is the role of communities, especially when we talk about monitoring and reporting violations that they observe and that come from the business investments that we're talking about. John, if you could just help us respond to those two questions. Do you think our regulatory systems are enough to respond to violations, land violations that come from the business investors or from the businesses, both government and private? You have the mic, John.
Thank you very much. I'll start by what are the roles of citizens, especially in reporting these violations. With our experience in this journey towards justice in regards to land, one particular community journey that has stayed with us, it's not because it was unique, but because it reflected the experience of many communities across Kenya. In early 2024, that is, our organization began engaging residents across Kiambu County, and following growing concerns around the implementation of the Kiambu County Valuation and Rating Act of 2016. At first glance, many people thought this was simply about paying land rates, but there were more to that when we listened to people. The more we realized that the conversation was never really about taxation, it was about trust. It was about whether people felt heard. It was about whether this discussion affected something as important as their land had been made with them or for them. We moved from one community meeting to another. We kept hearing the same question. We tend to, ask different or receive different questions from citizens. Who decided this for us? Were citizens consulted? Can our freehold lands really attract these rates that we are seeing in this law? If I fail to pay, what are the repercussions to my property? Where do I raise my concerns? So these were questions actually that were being raised by community members. And listening to those conversations, one thing that came out very clearly is that people are rarely angry simply because a policy exists. They become frustrated when they do not understand the policies, when they feel excluded from the processes, or when they believe there is no one willing to listen to them. That experience, reminds us that access to information is not just the constitutional right. It is also one of the most effective tools for preventing conflict. Once people understand what is happening, then they are able to participate. They are able to constructively engage themselves instead of reacting from fear or misinformation. Then we recognize that we need to be deliberate in decisions, not by beginning with protest or confrontation. We begin with civic education. We spend time, explaining what the Constitution says about people engagement, public participation. We also discussed about citizens' right and responsibility. We explained the role of people petition and the constitutional mechanisms that are available for engaging government. In many ways, our first responsibility was to speak on behalf of the communities, not to speak for them. By equipping communities to speak for themselves. And this is an important distinction because sometimes people assume that human rights defendants, who speak loudest are supposed to speak for the communities. But in reality, much of our work is about creating the condition, creating the environment for communities to participate in this decision making. As communities, become informed, something remarkable happened. Instead of responding with anger, they became organized. Instead of choosing confrontation, they chose constitutional engagement. Citizens from all the 12 sub-counties in Kiambu came together. More than 1,000 signatures were collected. Thousands of these residents formally petitioned the county assembly. As for me as a HRD, that was one of the strongest demonstrations of citizen mechanism that I witnessed. To redress or to be responsible when these violations happen to them, that they can actually participate and involve and engage government institutions that are responsible for making these laws, and also corporates and businesses that violate human rights. However, the experience also exposed an important weakness within the government systems, the business and corporate system, that when they presented these petitions to that is the county assembly, one thing that we kept getting, the questions that we kept getting from these communities, as our petitions be discussed, has any committee considered our concerns? Has any decision been made? Why has nobody communicated with us? Those questions, are just important as the petition itself, because public participation and also engagement of citizens in these issues that really affect them and involve them is not complete when government receives citizen views. It is complete when that institution, that corporate body, demonstrates that those views have genuinely be influenced, has genuinely be considered in making the final decision. That feedback loop is often missing, and that is what people begin to lose confidence in these institutions. Eventually, what started as a hope, might slowly turn into frustration, and experience fundamentally changed how we think about, access to remedy. Many people think of remedy as something that happens in court. And of course, institutions such as the Environment and Land Court plays an indispensable role in protecting land rights and resolving disputes. Likewise, the National Land Commission has one and most important mandate in matters of public land, compulsory acquisition, and historical land injustices. But from the community perspective, justice begins much earlier, as we had discussed earlier, than litigation. Justice begins when information is shared openly. It begins when institution responds promptly. It begins when grievances are acknowledged before they escalate into dispute. It begins then when dialogue remains open, even where agreements are not reached. If we strengthen those early stages, many conflicts will never find their way into courtrooms, and that, I believe, is the real spirit behind the Kenyan Constitution of Kenya 2010 and the Community Land Act of 2016, and also the NAP, the National Action Plan on Business Human Rights, as you had stated earlier. They do not simply provide remedies after harm occurs. They seek to prevent these harms before promoting participation, by promoting participation, transparency, accountability, and respect for human dignity from the very beginning. So the role and responsibility of citizens in reporting this violation begins earlier, in engaging these institutions, in asking questions, and also remedy, access to remedy. It is something else at times, it comes after litigation, but can we be in a position to see these remedies before litigations, take place? Back to you, Sally. Thank you.
Thank you so much, John, for those insights, and also for reminding us that we talk about remedy. We have multiple doors, we have many pathways, and we should not just focus on the courts. And they can also see from the charts, there are also responses that, if you look at our regulatory systems, our policies are more than enough, and even beyond courts. I think Senior Opaa has mentioned the commission itself is instituted to, first of all, be a structure that can also handle issues to do with to deal with disputes, and also resolve issues that are emanating from land. I think it's really key also that you've reminded us that, just apart from also dealing and resolving with issues and making sure that communities access justice when it comes to land issues, we also have structures like the National Action Plan on Business and Human Rights that we're really working towards to make sure that all these issues are prevented. And I think that's also something that the National Land Commission and other authorities or other institutions that we have are trying to do. I think our challenge has always been an implementation, and that's something that we can also discuss further, maybe in the next series of webinars that we'll be having. So thank you, gentlemen, for addressing those issues. I want to now give this platform to any of the participants to ask their questions verbally. I know I have received, I'm just looking at the questions that have come in. There's a question from Francis Karori. I don't know, Francis Karori, if you have the mic. My colleague is just giving you an opportunity to be able to speak so that you ask the question. But as you get the mic, maybe I can read your first question. I can see Francis. Francis, are you able to ask your questions verbally? You have the mic now? Yes, Adenike, you can go ahead. I can see your hand is up. Adenike, you can go ahead. I hope I'm pronouncing your name correctly. We can't hear you. I can see you're unmuted, but we can't hear you. Okay. Maybe I just go ahead and read. So the first question from Francis is that, what was the major challenge in implementing the Ndungu report? And I think this one is to Senior. I think this is yours, Opaa. What was the major challenge in implementing the Ndungu report on land justice? And then his second question is that most road construction in Kenya, after completing the road construction, they leave behind deep gullies where where they were getting materials which usually get filled with water. I think this comes to how they deal with the materials after road constructions. And I think this also creates social impact in terms of being dangerous to the community around them. So how does also the commission make sure that that's dealt with? Is it even like the commission's role? Opaa, I think you can deal with that. The Ndungu report and the issue of the road construction, if it's, and then I'll read the other questions. Senior.
Thank you once again, Sally. Let me handle the first part of the question regarding the challenge on implementation of the famous Ndungu report. You are aware, just again to bring members up to speed, particularly for those who don't understand the Ndungu report, the Ndungu Commission was established basically to investigate some of these illegal or irregular allocations of public land, and they established a long list of public lands that were illegally or irregularly allocated to individuals and entities, private in this case. The main challenge here, Sally and colleagues, is the goodwill. And I think one of the members of this particular panel or attendees has already alluded to the fact that we have a robust constitution, we have very robust legislation or legislative frameworks and statutes. Apparently, it is the goodwill that is creating the disconnect between the law or what is provided for in paper vis-a-vis the practice. So my take, which is of course opinion, which is highly considered, is the goodwill. When you look at the Ndungu report and the listing of the beneficiaries of such irregular allocations, and of course your guess would be as good as mine, how best do you marshal goodwill? And for me, the goodwill must come from the top, from the executive, that we are ready to implement the Ndungu report to the letter as a government, and that we want to ensure that that particular Ndungu report is implemented. Of course, part of the Ndungu report implementation on public land, recovery of public land that were illegally or irregularly allocated to private individuals, that particular docket or that particular mandate has also been bestowed to the National Land Commission. And I talked about this when you look at Article 66 of the Constitution, that talks about the power of the Commission to review grants and dispositions of titles. That is where those particular illegal allocations are supposed to be reviewed and revoked. Now, the lack of goodwill has occasioned the delay in adequate implementation of the Ndungu report. And of course, you see that manifesting in the legal regime that was governing the review of grants. It was also timed. And by design or as a structural deficiency, the law was designed therefore to fail and not to ensure that the recovery of these public assets are done by the National Land Commission. There are a number of public lands that were illegally allocated. But then when you time that process, because recovering even just one property, and you must have seen this within the even the Ethics and Anti-Corruption Commission, that recovering even one property is not a simple joke. You need a lot of evidence to make sure or to ensure that that particular property, the title, the purported title is nullified in accordance to the law and the Constitution and Article 40, that titles are only titles when they meet the legal threshold, when they were procedurally and lawfully acquired. Otherwise, they are papers, like any other paper. So in this regard, I see the goodwill issue that kind of went into the law or the statute and kind of timed this process, which is so important for Kenyans to get back which that belongs to them. Remember, it is public land, which the Ndungu report also alluded to, that belong to all of us, the 56 millions of us. We enjoy that Teina, whether I'm at Turkana, in Lokicha, I have some land somewhere in Kiambu County, which is called public land under the national government, and of course administered and managed by the National Land Commission. So when you look at the principle of equitable land governance or equitable land access, then you find it within the purview of that publicness of our land resources. So I see that goodwill as the main issue here, that and of course it is tied to the aspect of politicization of land. When land becomes politicized, that we are able to move emotions or invoke emotions of our local communities and say, now they are getting us, or we are being targeted, then that completely derails the very intent or good intent of recovering illegally and unlawfully acquired public land. So those two for me would be very, very important, that we become deliberate. We become completely deliberate that we want the Ndungu report implemented to the letter. And of course, now I'm seeing that the courts are helping us, the Environment and Land Court are helping us to achieve that, because we now have the National Land Commission Act amended 2025, which has now provided or removed that timeline for the review of grants and disposition of title. So the commission now is better placed, or is sitting at a better pedestal to review those grants of public land that were illegally and irregularly allocated, and of course some of them are falling within the Ndungu report. Some of them, of course, are our natural resources, part of our forests, part of our water bodies. They were illegally and irregularly allocated to private entities. So Kenyans cannot enjoy those particular resources and utilize them for public purpose. So allow me to rest it there for that particular challenge or issue on road construction and the establishment of deep gullies or pits. Well, the issue here is two parts. Part one is that when you look at the environment and social impact assessment and that process or procedure, one of the things that is always provided for within that particular framework is the establishment by that consultant calling himself or herself the environment lead expert, who carries out the EIA or the ASIA. But in that requirement, they're supposed to have a very robust environment and social management plan. And I know, and I've read a lot of those ASIA reports, and they capture that. But the issue here, what is written in law and what is written in those frameworks, especially EIAs or ASIAs, are not what are translated because of ineffective monitoring system by the respective duty bearers. In this case, I would call it NEMA. That we put it in black and white, that we will actually ensure that the project restores the environment upon completion. For example, if it's a mining, the excavation issues. But then who monitors that to ensure that that particular excavator undertakes a complete rehabilitation and restoration of the degraded site? We would expect NEMA, because one, NEMA has an enforcement capacity. They have a police wing to ensure that those particular conditions within the EIA are implemented. So there's that disconnect in terms of one, capacity of our institutions, which have enforcement roles, but also we see I would call it a governance failure, that we may also look the other side, especially when we get a small amount of money by the proponent or the excavator. Then you are able to see a governance failure, which is deliberate or systemic. Back to you, Sally. You are muted, Sally. You are muted.
Thank you for being able to notice when I'm muted, I think, through my camera. Sorry for that. So to the third question, I think a question from Joseph Maina. Let me just know by a show of hand if there's anyone who wants us to give them the mic so that they ask their questions verbally. This webinar was scheduled for 2 hours. We still have about 30 minutes to our conclusion. So I think we can still address the question. So I'll read the question from Maina. He asks that, what responsibilities do business and investors have when operating on land that is subject to historical land injustice claims? And how should they provide remedies where harm has already occurred? Because I had to also ask that on the point of how can government of Kenya, the National Land Commission, the judiciary and businesses and affected communities work together to provide timely, transparent and sustainable solutions to historical land injustices? And what practical, I think this was responded to. And finally, that what practical justice pathways, including court process, mediation, restitution and compensation, land redistribution and community dialogue offer most effective and lasting remedies? So I think he's asking of the available justice pathways, which can we say is most effective to offer remedy to these violations? I don't know if John or Opaa, anyone who wants to answer that. As you come on board, let me just ask another question so that I finish with the question and you can be able to respond. So another question, still from Joseph Maina. He asks that how can Kenya deliver effective justice and meaningful reparations, especially to Mau Mau veterans and the descendants who lost land through colonial dispossession, while balancing the rights of the current landowners. He also asks that what legal and institutional barriers continue to prevent the Mau Mau veterans and affected communities from accessing justice, and what reforms are needed to also remove those barriers. John Obonyo asks that, and he's specifically directing this to the commission, so that's to you, Senior Opaa, that most business entities expand their operations by encroaching into riparian reserves, and also they destroy the ecosystem. So this has been a source of institutional conflict, especially between KFS and NEMA, and you wonder what our value system is like. So after evaluation, does the commission provide the evaluation reports, especially for mega projects? For Adenike, I think Adenike was able to put his question through the Q&A. He asks, and he also directs it to the commission, that interviews with host communities of energy projects raise concerns about the lengthy process of registration and the cost. Without title documents, these communities become vulnerable to unfair investor deals. And I think this is the situation, in maybe Turkana and the extraction of oils. And he says that they become vulnerable to unfair investor deals and may not likely be compensated when their lands are acquired. How can this be resolved in Kenya? I think, Senior, this is in regards to the adjudication of the unadjudicated land especially. So those are the questions. So any of you can go ahead, can start. I don't know if Ben or John, you want to start? Senior, there are a lot of questions directed to you. Maybe you take the mic.
Sorry.
Sorry, John.
Maybe John can go because he has
let me take on the first question. Responsibility of what responsibility do businesses and investors have when operating on lands that is subject to historical land injustices? This is a very important question because businesses and investors are increasingly operating in context where land carries a long history and unresolved grievances. For instance, in Kenya, many communities, continue to live with the legacy of colonial dispossession, irregular allocation, compulsory acquisitions, and also historical injustices. So, from my perspective, businesses cannot assume that because land has been legally acquired, all underlying human rights concerns have been resolved. As we look through the United Nations Guiding Principles on Business and Human Rights, and reflecting on the NAP on business and human rights, it is very clear that businesses have a responsibility to respect human rights, and also the state has a responsibility to consider these human rights. So this means conducting human rights due diligence before acquiring or investing in lands becomes a priority. Businesses or investors should not just identify historical claims, they should understand the social and cultural significance of these lands, engaging affected communities, and also engaging HRDs at the initial stages. On how can the government of Kenya, the National Land Commission, and judiciary, businesses, and affected communities work? How can they work together with communities, these government entities? First thing, we need to agree that resolving historical land dispute requires collaboration because no single institution can solve these issues alone. for the government, it has a primary constitutional duty to protect land rights, implement land laws, and strengthen land administration system by ensuring that public participation is meaningful rather than procedural. The National Land Commission, the NLC, has a particular importance of investigating these historical land injustices and overseeing compulsory acquisition processes, and also promoting equitable access to land. For the judiciary under the Environment and Land Court, it remains an essential part of this ecosystem in interpreting the Constitution and enforcing the land rights by providing independent decisions or justice where disputes cannot be resolved through dialogue. For businesses, they should engage communities and HRDs at an early stage, share information transparently, as we had discussed earlier, and also conduct environmental and human rights due diligence. As for the communities, it is their role to see that they actively participate in this public consultation, they actively organize themselves peacefully, and also document their concerns and use constitutional and legal mechanisms to seek accountability. And as an organization, this is something that we really do at the community, where we are used as a platform to organize communities and to guide them to the right direction that they need to adjudicate their issues and also get results after setting out these issues across. I think I'll leave up to that for my colleague Ben to address some other questions. Thanks.
Yeah, and Sally, for me, I will go to the last one. I will start with the last one on interviews with the communities around energy projects. Is kind of revealing unfair compensation and of course issues around governance. And one of the issues here, Sally, and I think the person who asked the question was spot on, that it's about the delayed community land registration. And I know my interaction with the courts is that even resolving disputes within unregistered community lands in Kenya is really a major challenge for our courts, or the judiciary, the Environment and Land Court in particular, because of lack of clear demarcations and adjudication documents, particularly to ascertain tenure rights and ensure that communities effectively can demand for their rights and of course document any violation thereunto. In this particular context, and giving practical example using the Turkana or Takana, depending on where you came from in terms of schooling, you will understand, Sally, that currently the community land in Kenya is actually the biggest chunk of land. Turkana as a whole, I would say, with the exception of few pockets of public institutional land, largely the lands are classified as community. Unfortunately, a very small percentage has been registered. That means that for the Turkana communities to lay proper claim and meaningfully engage with an investor on their land will become a slightly big issue, because it is not easily understood, or they may not be understood very easily and straightforward, in a straightforward manner, that they are really the actual claimants, because they do not have documentation to those particular claims. And that's why for us as a commission, we are championing, working closely with the Ministry of Land and Physical Planning to spearhead the completion of registration of community land that would give the communities the power to negotiate over their own land, because the community land belongs to those particular communities, especially once they are registered. Constitutionally, before they are registered, those lands are held in trust by the respective county governments. And we know what that means when it comes to compensation. And we have had issues where compensation for unregistered community land has been effected, and that such monies have been transferred to the county governments. We know what has happened. So what we are saying is that we must look at the fast tracking. I know for now we are working on the master plan for fast tracking the registration of community land. That was basically the directive by His Excellency the President last year when we held the pastoralist summit. in Garissa. There was a directive. So we are working on a master plan that would help to bolster and enhance, or rather fast track the registration so that communities have secure tenure, they're able to bargain, and of course eliminate some of these anomalies in regards to unfair compensation, because they will be having their tenure documents right. But still, the commission is a safeguard institution, particularly for unregistered community land. And the reason why the commission was actually placed at the center of unregistered community land is because of that safeguard responsibility to protect these rights and interests. The weakness point, or the point of weakness here, is that some of these investors go ahead and either negotiate with the respective county governments and even some of the communities or elites within those communities without even engaging the National Land Commission, which is the safeguard body established in the Constitution to protect some of these interests and rights of local communities whose lands have not been registered. So that is my understanding. And if you look at, for example, Section 38 of the Mining Act 2016, it provides that for every mining company or mining operations on unregistered community land, then there is need to obtain a consent from the National Land Commission. That clearly depicts the safeguard responsibility of the National Land Commission. Unfortunately, sometimes some of these procedures, some of these operations are conducted without our consent or even awareness. Valuation reports for major projects, yes, all Kenyans have a right to ask for information, and that right is already provided for in the Constitution. The right to access information is provided for, and I don't think if anybody wants any report from the National Land Commission that they would be barred from getting that. If you have written to the Commission demanding for a particular valuation report for a major project, then you still have another window. The Commission on Administration of Justice, the Ombudsman, can write to them, and they are able to still compel the National Land Commission, and they do that a lot. I read a lot about the Ombudsman and the complaints coming from the public through them, and we address that even through the Ombudsman. So the valuation reports are public documents, especially for major projects that are of public interest or are public purpose in nature. So the Kenyans have a right to access these reports that are public, so that they are also able to scrutinize and also hold the National Land Commission accountable, including its officers. Businesses on expanding on riparian reserves and contributing to conflict between KFS and NEMA. This is true. We see a complete disregard to the rule of law and constitutionalism for some businesses. Of course, we also have good practices where certain businesses have operated within the ambit of the law and the Constitution, and of course seeking advisories in regards to the established setback lines for riparian reserves, for our wetlands, or even for forests in terms of the buffer zones. So we see that as a major challenge where we have a multiplicity or multiplex of institutions with overlapping jurisdiction, again bringing confusion even to the very business owners or private investors and even local communities. And that is also a challenge that we may want to pick in terms of land rights issues or land business and human rights issues within the context of land and natural resources. The other issue that I wanted to talk about is the colonial operation. I think my colleague has talked about it, that Kenyans have that legacy of oppression and colonialism, and of course it has been kind of carried through by many of us, and there will always be, or we will always find that certain injustices go back to the old colonial regime. One of the things that, for me, looking at the current legislation and even the framework that we have, the governance framework, would be for you to establish, if truly you believe that there is truly a historical injustice that were either committed by the colonialists or whatever manner by the government at that time, before 2010, then you are able to bring that particular claim before the competent authority established in the Constitution, the National Land Commission, so that the Commission is able to process that and advise or provide recommendations on appropriate remedies in that particular regard. So Kenyans should not shy away. The National Land Commission is properly clothed with jurisdiction, and the National Land Commission is properly established currently with full commission at capacity to do their work, So your work as a member of the public or as a citizen of the Republic of Kenya is to understand that particular claim and be supported to craft your claim to meet that historical land injustice claim and forward that to the Commission for processing. That for me is your right, and you don't owe anybody allegiance to do that. Yeah, there are so many reforms that are going on to effectuate or to streamline land reforms. Currently, we are reviewing the national land policy to capture and encapsulate business and human rights issues in the context of land and investments on land. Of course, our engagement even also with the judiciary, including the last one being last week during the annual Judges Conference, Environment and Land Court Annual Judges Conference, it emerged, and I think this statement was actually provided for by none other than the Deputy Chief Justice of the Republic of Kenya. And she stated to the judges at that meeting that it is one thing for you to have a performance that is based on the number of cases that you are churning out of the court. But Kenyans do not bother so much about the number of cases you are churning out of the courts. They bother so much on the impact of those particular judgments. Do they make sense? Do they bring the much needed social transformation within our society? That was a challenge. And so I would tell you without any doubt in my mind, Sally, that there are a lot of reforms that are happening to help Kenyans access justice. One of the things that also came out, for example, in the Mining Act is the need for to establish a mining rights tribunal. Currently, there's none. So all disputes around mining, eventually, apart from what is provided for in law, under the the cabinet secretary in charge of mining and the dispute resolution around that, which Kenyans felt that these ones are not necessarily appropriate, or that the cabinet secretary for mining has a lot of sweeping powers. And so most people will proceed to court, and it becomes very difficult for judges to unseat a justice seeker who is already seated at the seat of justice. So what is important here, Sally, as I wrap it up, is that Kenyans are empowered to demand justice, to access justice, and to promote justice. But also they have a duty to ensure that they also live in accordance or within the beacons of the law. Thank you. Back to you, Sally.
Wow. I think that's very, I wanted to say impressive. Let me just say that's very impressive. I think something to note, a lesson that you also learned from the conference that was held last month, that it's not just the number of cases, and I would also add it's not also just the number of legislations or reforms that we have, but it's the impact that these structural decisions and issues have, the impact that they have on the community. So thank you, Ben. Thank you, John. I can see we don't have any more questions. We just have comments. I can see Ngala is commenting on something on the NAP. We've seen that you're raising some of the what the NAP is saying on the historical land injustices. And I think Opaa has mentioned that they are actually now sitting with the committee who's reviewing the National Action Plan on Business and Human Rights to see that some of the issues and challenges that we are discussing here are addressed in the reviewed policies. Sen, I can see you. You're saying our regulations are more than enough. Yes, I think we agree. What lacks is goodwill. I think we will also discuss that goodwill as an issue that maybe we might. I don't know what we can prefer or the solution we can prefer from to entrench goodwill, especially in our institutions when it comes to land governance. But we see the comment. Okwaro, we see the comment. Felix is bringing up an issue that why would government come after one has found minerals in their own land? I think that's to do with issues of knowledge on what's public land, what's private land, and what police power do government have on land generally. I know we always say as a people that all land belongs to the people of Kenya. But we also need to understand, as we've been reminded here, we have a duty to understand the concepts of land as we talk about land issues, but also other rights. Patrick Masila, you are saying a major gap in seeking remedies for human rights violations is the issue. So we need to strengthen that in how we address remedy issues. we've been reminded here, even as we talk about pathways to justice, we are not only looking at courts, we're looking at institutions created by our constitutions to look at or to address some of the issues we're talking about, like the commission. We're also looking at other avenues, like community avenues that can help us address some of these issues. And I think as a project, the Cultivating Justice project, we've also taken cognizance of the fact that dialogue is also a platform that we can achieve justice. Prince Kamau, you're saying that the issue of compensation of public land during investor transfer is huge. So you're agreeing that compensation is still an issue that we continuously need to see how it's dealt with. There's lack of clear guidelines on how citizens can go after community lands. So I think also an issue that is coming up, ladies and gentlemen, is how do we continuously disseminate information when it comes to land governance and land rights to our community so that they adequately also participate. We have a participant from Turkana who's reminding us that we have about 3 communities in Turkana who have registered their land, even as we talk about issue of land adjudication. So that progress made there. I can see a question from Jerry Mangi. What role does NLC have in monitoring how proceeds from community land that has been commercialized are used? I don't know if we will have time to address that. I think we will have time to address that. So just how NLC is monitoring. I think this is also key to the areas that we're talking about in Turkana, how NLC can monitor that the proceeds from community land, if land is not registered, are not being commercialized, because as you know, they are supposed to be held in trust by the county government. Is there a commission working in Kenya? I will say, this is a comment, and Opaa, maybe you can also take this to maybe the rest of the colleagues and the commissioner, that if there's a commission working in Kenya, it is the National Land Commission. Yeah, I think there's another long one here. The Treasury has started to move to value and commercialize public land for PPPs, leases, and joint ventures. What safeguards ensure this doesn't sweep in community or unregistered land where rights haven't been formalized, given that over 60% of Kenyan land mass is community land, much of it unregistered? I think we've discussed that. How does NLC ensure the asset register valuation exercise does not misclassify community land as public land and expose it to commercialization without FPIC, free, prior, and informed consent? So I think the rest is just to appreciate that the discussion has been rich. Yes, what is the position of the National Land Policy Review process? I think a lot of these questions, Opaa, are directed to you, I think by virtue of you being government as well, and also coming from the institution that has the biggest mandate when it comes to management of land. So just tell us also what is the position of the national, where are we at with the National Land Policy Review process? Yes, I think I have actually ensured that I have read almost all your comments. So just to address the few comments, any of us, as we draw to a close, the ones that I've just read, where are we at with the National Land Policy, and also the issue of the proceeds from the unregistered lands. Opaa, to you.
Yeah, thank you. Yeah, let me start, Sally, then I'll leave it to my colleague John. On the status of the National Land Policy, the ministry, it started with the National Land Commission as required in the Constitution, that the National Land Commission must provide a comprehensive advisory on the National Land Policy for the Republic of Kenya. That is provided for as one of the functions of the National Land Commission in Article 67, Sub-Article 2 of our Constitution. Now, when you look at that, the National Land Commission actually mobilized itself and, of course, was able to provide that advisory. And that advisory has set the stage and established the foundation upon which a new National Land Policy, remember the one that we have is the 2009, that kind of informed, not kind of, but indeed informed the Constitution of Kenya 2010. If you read the National Land Policy 2009, that session of paper alongside the Constitution of Kenya 2010, then you'll find it's a mirror. The Constitution is a mirror of what was provided for in the National Land Policy, especially when you look at chapter 5 on land and environment. One of the things that we have done is the ministry now has taken it over as required, and now they have established an interministerial technical team together with an interministerial coordination team. And of course, as we speak, in terms of the status, there's a draft National Land Policy 2025 that is supposed to go through, or actually has started going through the public participation phase. I recall last year, there were invitations for comments, and there was a dedicated email where members of the public were required to channel some of their inputs into this important land governance process. The next phase for us, because luckily I belong to that team, or I sit in that committee developing or spearheading that policy. Currently, we are basically waiting for resources to move into the counties and engage Kenyans at the county level, because this is one of those policies that is at the heart of their development agenda, and of course looking at the centrality of land in the lives and well-being of the people of Kenya, because the Kenyan economy is basically a land economy. So you cannot purport to have done public participation by inviting comments through virtual means and say or state with authority that public participation met the minimum threshold provided for under the Constitution and even as guided by the Supreme Court judgment. So that's why the Ministry of Land is now mobilizing resources to go to the counties and conduct physical consultations and public participation to generate additional ideas and thoughts of how Kenyans would want to see their new national land policy and what issues are emerging that they would want captured and addressed by their current national land policy. That is the state, and you will be notified when that starts. So the dates are not yet established because of challenges around resource constraints. Asset register, misclassified community land as public land. Well, that one is, if it has happened, it's unfortunate, but I know that the law has already secured and protected community land. And it has also said that you can only convert community land to public land through surrender or through compulsory acquisition. Remember, my understanding of the Constitution, Sally and colleagues, is that broadly, while we talk about Article 61 of the Constitution giving us three broad categories of land, as public, followed by community and private, my understanding is that generally we have two broad categories of land. So land in Kenya can either be public or private, because the community lands are also private to those particular communities. So that is why we say that we must do compulsory acquisition and pay those communities if we are to acquire their property, because it is private to them. That is my understanding. And so in that regard, if it has happened, it is unfortunate, but the law has provided very clear safety net and safeguard in terms of protecting community land, and that community land belongs to the specific communities, and you cannot acquire them arbitrarily. Public participation for national land policy, I've said that, I've talked about it. How does the National Land Commission monitor proceeds looming or coming from community land in this regard? Yeah, this is quite interesting, but a bit nuanced and complex. One of the things that we do as National Land Commission, of course, is to ensure that communities have their certificate of title, which is the legal document that ascertains their power in terms of property rights. And so we are fast tracking that in various counties where this is lacking, so that communities are able to meaningfully engage investors so that they get better proceeds from their land resources and developments thereon. The challenge we have here is that once communities register, then once they register, then part of our safeguard responsibility is taken away, because now that land is private to that particular registered community, because now they do their transactions according to the governance that they established, in this case, the Community Land Management Committee. Now, that is the one that now negotiates and does their agreements, including negotiations, and even can enter into leases with a prospective investor. Just like I would enter into an agreement with a prospective investor on my private property, on my private land, which is again guaranteed under Article 40 of the Constitution. So when you look at these particular proceeds, unless the Commission is properly engaged and is properly brought on board in terms of this kind of arrangements, then we say that we may not have jurisdiction. But we may have jurisdiction when it comes to oversight, when it comes to regulating the use of that particular land under Section 8 of the Land Act, which again effectuates or breathes life to Article 66 of the Constitution, which basically talks about the power, the police power of the state in that regard. So that is the position. But I also saw a question, Sally, as I wrap it up, on the Dandora dump site, and this is from Patrick Mudama. I'm not sure exactly what Patrick really wanted with Dandora dump site. I don't know whether he wanted to understand the Taina or the pollution or the chemicals around it. It was not very clear to me. Back to you, Sally. Thank you.
Yes, thank you so much. We might not have the time for maybe, was it Patrick, to elaborate? But Patrick, you can just ensure that maybe you leave it at the chat so that we see how to address it in our next series of webinars. But I want to take this opportunity, members, it's now 3:54, so we have about 6 minutes. So we have come to the end of this webinar, and I really want to thank our speakers today. That's John Muchori and Ben Opaa. I think because of time, I would have loved to give you an opportunity to give your closing remarks. But forgive me, I will hold that because you're trying to create a track record of keeping time. We start on time and we end on time. As we close, I think we also take note of some of the challenges that we have continuously discussed here that we are facing when it comes to land governance. I think we've talked about the weak governance issues. But not all is lost. I think a lot of solutions and a lot of hope has been given in this discussion, that we have a lot of policy reforms, not just policy, but also institutional reforms that are also geared towards addressing some of the weak governance issues that we are seeing. So we remain hopeful, comrades, as people in this sector. But also take cognizance that even as we are here, and I know a lot of our participants here are also human rights defenders who work with communities at the grassroots, that we also have a role as human rights defenders working at the community level, and our role also extends to making sure that justice is done when it comes to these issues, and not just creating linkages for communities, but also being part of the solution. And I was looking at some of the comments in the comment section, Senior Opaa, and also for you to take note. I think there's something that is coming up. Maybe there is a need for sensitization on land rights. And maybe we can consider in the next series of webinars to do a deep dive into the basics of land, even as we discuss these issues. I think that will also help us to make sure that the communities achieve justice. Just to remind members that the review of the National Action Plan on Business and Human Rights is continuing. We're doing an assessment to develop a parallel report that we will use together with government, to collaborate with government in terms of giving evidence on what really needs to be taken in consideration during the review. So I think we'll also be using also this opportunity to gather more evidence and more information to inform that process. So I don't want to bore you with a lot. I want to end this webinar now, but just to reiterate that we're very grateful for our speakers for accepting our invitation and also for sharing your knowledge. Members, you realize that we do not have a PowerPoint presentation, and it means that the people we are bringing to speak in these webinars are people who have the information at their fingertips. They are experts at these issues, and we are hopeful. We are hopeful that this dialogue platform will also be will also create an opportunity for us to be able to address some of the challenges or some of the questions that we've always thought about, but have never had the platform to ask. So thank you very much, our speakers. Thank you, our participants, for getting into the webinar on time. And we were monitoring the number of participants. It's been stable. So we thank you for being here for 2 hours and for actively participating. So I'd like to end it here on behalf of Pamoja Trust and also on behalf of the Cultivating Justice Project, that is SEPCJ and also DCA. We thank you and we're grateful, and we'll also be sharing more information on the next webinar, even acknowledging that we need a deep dive into the basics of land. So I think we'll be able to share with you also the recording of this. You can check our socials or YouTube. The recording will be there for reference. So thank you and have a good evening.